practice law, ma'am. You don't
represent
need,
yourself or to follow the rules.
to practice law, you don't need to be a part of the bar association. Sorry. I already looked that up. Unless Mr. Lou Dang can show me a license, and I'm not talking about a bar license as well, I would dearly appreciate that as well. But yes, I'd rather represent myself.
Every time you appear in front of me representing yourself, I'm going to advise you again that it's a bad idea. I'm going to advise you again that you'll be held to the same standard as an attorney. And I'm required to do that. If it becomes a problem for you that I advise you that you'd be better served by having an attorney, then we're not going to get along very well, sir. I'm doing what I am required to do by law.
Yes, ma'am.
I've read the motion. In fact, I've read it a couple of times and listened to what you have said here today. And I agree with Mr. Banner that there is no support for what you're requesting, and and both motions are denied. The oral motion to dismiss that you made today,
How you gonna deny
for a subpoena ducis tecum? They're both denied.
Excuse me. How you gonna deny a fact that basically is not solidified going on at that point in time? Now here it is. I'm in U of M.
Mr. Cunningham, I'm going to mute you now so that I can speak.
Right, Mr. Cunningham, I have a hard time following you and following what you're asking for. And I've had the same problem in the past several hearings as well.
Yes, ma'am.
Today's a pretrial. It's not scheduled as a motion hearing.
Representing himself, and as this is the start of a new proceeding, the people just ask that the defendant be advised of his rights to representation.
I'm advised on my rights to representation right now. I'm waiting for the subpoena to come back. So I'm asking the court for a adjournment until the 31st or a little bit after the 31st of May, considering the subpoena has not came back and nobody has not contacted me since I put the subpoena in. If y'all need a reference of basically when the subpoena was sent out, that would be I can send that to you. And then also, as far as the original witness is not on the witness list, the accuser, quote unquote. And then also, Your Honor, I was supposed to ask for a motion for the case in whole with the videotapes and the transcripts, which still has not been sent out to me. So I'm also waiting for that as well, Your Honor.
Mr. Cunningham, it's generally considered to be a very bad idea to represent yourself. I want to advise you that if you do choose to represent yourself, that you're held to the same standards as an attorney. And as you know, attorneys go to school for years to learn how to do what they do. I won't be able to help you to
practice law, ma'am. You don't need
to follow the rules.
To practice law, you don't need to be a part of the bar association. Sorry. I already looked that up. Unless Mr. Lou Dang can show me a license, and I'm not talking about a bar license as well, I would dearly appreciate that as well. But yes, I'd rather represent myself. Man.
Okay.
If you want to show me a license,
what kind of
we
license
can go
are
all day. Actually, I'm talking about the
Mr.
practice law, ma'am. I'm talking about the practice law. You don't have to have a license to practice law. I mean, this is not the first time I've been in front of you.
I know that, sir. You said that you wanted to see a copy of Mr. Danner's
license. Okay, well, you just kind of. I mean, I'm not taking it as a threat or anything, but you just stated it because he went to law school or whatever. That basically, I still don't know my rights, ma'am. So one of my rights I'm asking is basically, yes, ma'am.
I'm required by law to advise you that it's a bad idea for you to represent yourself. I'm not doing it to
so is that
threaten you or intimidate you or scare you or anything else. I'm doing it because I'm required to.
Well, ma'am, I'm gonna ask this question then, ma'am. Is that advisement privately or commercially, ma'am? Is that advisement privately or commercially, ma'am? Is that advisement privately or commercially? Are you advising me commercially or privately? You just stated it, advising.
I'm advising you on the record.
Basically, attorney. I'm
advising you on the record.
So would that be
What, sir?
privately? Would that be commercially, ma'am?
It's neither. It's on the record.
How is it neither on the record when basically it's a you're not my attorney, so how can you advise me to do anything?
There are lots of things.
It's a question,
ma'am.
ma'am. It's a question, ma'am. I'm just asking, how can you advise me to do anything unless you're a representative, unless you some type of representative, have some type of contract with the Cunningham party? Let me know, ma'am. Unless other than that, you're an arbitrator.
Mr.
Sorry.
Cunningham, every time that you appear in front of me when you're representing yourself, I'm going to give you the same advice, which is that you would be better served by having an attorney. I have to
Such
do
as
that.
the last three judges, ma'am.
Excuse me, sir.
Go ahead,
Sir,
ma'am.
give me a minute to talk. Every time you appear in front of me representing yourself, I'm going to advise you again that it's a bad idea. I'm going to advise you again that you'll be held to the same standard as an attorney. And I'm required to do that. If it becomes a problem for you that I advise you that you'd be better served by having an attorney, then we're not going to get along very well, sir. I'm doing what I am required to do by law, which is to advise you on the record that you would be better served by having an attorney. And I'm telling you right now, I'm going to do it every time that you appear.
Well, to get along, first of all, to get along and be in basically correct court proceedings and facts, it will be two different things, man. So to get along,
I didn't ask you anything, sir.
It sounded like a threat. Excuse me.
I did not ask you any
I just
questions.
listened to what you had to say, man. You're cutting me off. I just went through
Mr.
this
Cunningham?
with Ms. Perry, man. I was only stating my claim, man. I thought it was my turn to talk. If it's not my turn to talk, just let me know. I thought it was my turn to talk. If it's not, just let me know. But I thought it was my turn to talk. You just interrupted me.
What do you want to say to me, sir?
I just said what I was saying. I was trying to get a adjournment until May 31st until basically I get the information back from the subpoenas. And I'm actually basically Lou Dane, the attorney, to actually have the original witness, Calvin Kleinoff, on his witness list, man. That's all I'm asking. Other than that, I'm not asking anything else.
Your Honor,
Yes.
two things. First, if Mr. Cunningham would like an adjournment of this matter, I have no objection to Mr. Cunningham receiving an adjournment of this matter whatsoever. Secondly, the people are under no obligation whatsoever unless this matter is set for trial to produce any witness unless there is an evidentiary hearing in which there's a motion that is filed for an evidentiary hearing requesting the admission of an individual party who will be considered a res gestae witness to this matter. As there has been no articulation as such, and as Magistrate Garwood is not a party to the case, and also since Officer Kavanaugh, I believe in this case, would only be the officer who swore out the information, or in this case, or the complaint. In this case, that Mr. Cunningham, would you mind 1 second, sir? Would you mind 1 second? Thank you, sir. So, Your Honor, if Mr. Cunningham wants a trial to be able to exercise the court's authority of subpoena, then he can request a trial date and then try to have that occur. Or he can file the proper motion, as I am in receipt of a motion that is not the proper motion to be filed, nor is the relief that he is seeking such relief that this court would have the authority to grant. So it is my understanding that even if he wanted the adjournment or whatever subpoenas to go out or anything of that nature, that would be a non-starter, as that is not what would occur, as none of this was properly done according to the court rules or case law. So, but if he does want a trial, or if he wants, he can request a trial, and then he would be able to subpoena witnesses to be there to testify at a trial, as the court would fully advise him of that right. Beyond that, Your Honor, I am not in receipt of any intelligible motion in which he has stated any kind of claim in which this court could grant any relief.
Okay, we'll adjourn to May 31.
Excuse me, ma'am. I wasn't done talking, ma'am. If you look at first the document A1 basically was sent to the Cunningham party. What was it? October 26, 2020. Basically, you look at A1 evidence. Evidence. The states on there, Calvin Orion Kavanaugh. He's not an officer. It just says original witness. Now, the original witness, basically, what we haven't had an motion for is basically for the head of the head of the case. I can't think of his name. Matthews. That basically, quote unquote, they tried to amend in that him to be the original witness when basically the original witness was actually Ryan Kavanaugh, who basically is not a complainant officer, is not a officer. He was a regular civilian on the road that basically they try to put in after the fact that basically I was not supposed to be on U of M territory. And then they searched my property. And then from there, they try to add in Mr. Matthews as the original witness when basically he cannot be the original witness if he's in charge of the case. That's kind of like a contradiction. And then at the same point in time, he did not sign up under a penalty of perjury as well. So, I mean, I'm confused here, man, at this point in time. But I will take the adjournment to May 30, a little bit after May 31st to find out if I can get the rest of my my subpoena to go further and more than that. So if we can go to subpoena 31st, from there, my motion for a subpoena from there, I would gladly enlighten you about this case.
All right, were you asking for May 31st or another date?
I was asking just a little bit after May 31st would be much appealing over on my side, ma'am.
June 7, is that all right?
Yes, ma'am. That'd definitely be okay.
All right,
What time would that be,
June
ma'am?
7. 1:30.
Thank you.
You're welcome.
Recalling number 19 and 20, People versus Don Lee.
I'm fine. How are you?
I'm doing all right.
All right, Mr. Weems, are you wishing to continue to represent yourself?
Yes, ma'am.
And you understand that that most folks would say that's a terrible idea and that you'll do much better with an attorney?
Yes, ma'am.
Do you understand that if you represent yourself, you still need to comply with all the court rules and the law, and that you're not given a break just because you have not, because you don't have a law license?
Yes, ma'am.
All right, we're scheduled for a pretrial today. Mr. Weems, were you wishing to go to trial?
Actually, I don't know. Can I go in a breakout with, I guess it's the prosecutor or whoever I need to be talking to?
If you want to talk with him, then I will give you an adjournment and let you talk with him another time, but I need him to run the docket.
Yes, Your Honor, I have no problem with an adjournment in this matter. The people did communicate an offer the last time that we were on the docket, and that offer still stands as pleading to count 1, dismissing the remainder with a probationary sentence agreement. If the court would allow, I can give Mr. Weems my contact information so he can call me if he has anything that he would like to discuss.
Mr. Weems, you need to remain on video, please. Did you hear what Mr. Danner said?
Yes, ma'am.
Okay, and would you like his contact information so you can speak with him?
Yes, ma'am.
Go ahead, Mr.
Alrighty.
Danner.
Okay, so the line to reach me here is, and my name is Lou Danner, so when you call, you just ask for Lou Danner. The number here is 734-222-6620. That is the way to reach me by phone. If you would like to email me at the prosecutor's office, it is my last name, Danner. So that's DANNERL, as in Lou, at washtenaw.org. You can feel free to email me there or to call the office line, and I will be more than happy to discuss this matter with you. And please be advised to not discuss any actual factual basis of the case, as I do not represent you, and I want to make sure you protect your constitutional interests and not say things to me that may be used against you later.
Yeah, I know who you are.
Mr. Weems, we tried to mail your birth certificate back to you and it came back as undeliverable. Is there another address that we could send it to?
Yep. Yes, ma'am.
All right, what is that?
No, Ypsilanti, Michigan. Sorry.
48197 or 98?
98, if I'm not mistaken.
Okay, very good. Thank you, Mr. Weems. We'll adjourn your matter to next week, to June 7. That'll be at 1:30, okay?
Mom's birthday. All right. Love you. Thank you.
Your Honor, is that the date that I just want to make sure there's enough time for Mr. Weems to actually reach out to me and contact me?
Yeah,
I know, does the 7th work for you to be able to reach out to me and discuss this case before that date? All right,
yes, sir.
he's nodding. Okay, thank you, sir.
Okay. You're all set, Mr. Weems.
All right, you guys have a nice one. Thank you.
Thank you, too.
Yep.
Number 15 on the docket, People versus Bobby Cunningham, 22147 FH.
Lou Danner for the people.
Cunningham here.
Mr. Cunningham, do you still wish to represent yourself?
Yes, remain as always, which basically I put in documentation sent to the court. May have you reviewed or made a decision from there. Go ahead now.
Mr. Cunningham, what I have from you was from April, and it appeared to be an attempt to write a subpoena.
Yes,
And
madam.
I'm sorry?
I say yes.
Okay.
Subpoena.
I'm not going to sign that subpoena. First of all, it's not in the right format. And second of all, it's directed to people who are not subject to subpoena, court officers.
All right, well, excuse me, that's only one of them. If I might, excuse me, quote unquote, put my words on top of your words. One of them, that's only one of them. The second one is actually showing, which I had wrote the subpoena for, stating when I had got identification within the jurisdiction. Now, two, the jurisdiction that I came from before I came here is not the same, madam. Sorry. At the same point in time, I have not got no correspondence with the subpoenas that I have put out, what I have put in the records myself, and also its contract to solidify these subpoenas to the necessary people that it's supposed to go to. Now, from there, I'm talking to you, which basically pre-trial, which is at this point in time, if you want to make a decision with or with not, I'm putting it out hopefully to the end of July, if possible, somewhere around 23, 25 days of the month of Roman calendar date 2022 July. So from there, from basically the subpoena that basically I'm trying to get to, which is supposed to be on the witness list, which is on the also, excuse me, I might be slurring my speech a little bit. Simple fact of the matter is I might be a little intimidated by basically who you may have associated with quote unquote RICO Act, which is you as well,
which has to do with housing and throughout this jurisdiction of the Washtenaw County. Now, excuse me. If you want to look at, which is basically supposed to be on their witness list, is basically the, motion for Bradley versus United States, which basically comes to the identification of what's jurisdictional act, what has to go by every constitutional state, basically including the United States, 10 mile additional law. I had a basic contract with a passport. Let's say it's from there. Now, what they sent me is basically within we can say go back to A1. Now, if we go back to A1, as far as the motion and also the other motion that I have put forth before me talking to you. Now, A1, as far as in the as far as the evidence, name and address, not correct. Now, the name and address is not correct, which basically, to me, has not been in any type of reference to why this is not correct. Now, the witness states, Ryan Kavanaugh. Now, Ryan Kavanaugh is not on the witness list, is what's basically I've been asking, and which basically, as far as the transcripts and the videotapes, you have not presented, or the attorneys, I just had a little hiccup because I'm down on battery, So they have not supplied me with the transcripts or the videotapes. It's supplied basically why they're stating that some of this documentation that they sent me is not agreeing to what they have already equivocated. Now, they tried to, move the primary witness. Now, with my primary witness, what I just stated is Ryan Kavanaugh. That's not on the witness list.
Okay, so Mr. Cunningham, I'm gonna stop you, Mr. Cunningham.
Yes, ma'am.
If there is a motion,
yes, ma'am.
Excuse me?
I'm asking to supply this information or bid this case. Simple.
If you're gonna make a Cunningham, it needs to be in writing. And the only
already in writing, ma'am. Whether the excuse me, I don't mean to interrupt, but whether Lou Sedan have justified and read through the motions and documents that's submitted, that's not on me, ma'am. I'm asking at this point in time, you subtract or dab it this case, or we go from there, which basically right now is only a motion, which basically, it will be under the RICO Act. Simple fact is you and him have ties to, such as the Housing Association. I'm just making a statement here. Simple fact of the matter is Housing Association, Washtenaw Association of a degree of basically to supply law or put knowledge of law to. It's kind of a little bit Greek, probably a little had some of the people, but at the end of the day, I'm just asking, he doesn't have the supply witness, basically Ryan Kavanaugh, on the document as a witness. If he doesn't have him on the witness, it's basically what they sent me to October 27th, 2020. Basically, I'm asking for this case to be dismissed, man. That's simple, cut, drive to what it is. Anything over there? I'm listening and understanding. Excuse me. I'm writing notes.
All right, Mr. Danner, would you like to respond?
Yes, Your Honor. In response to the motion for subpoena that is before this court, Your Honor, I'm asking that this court deny defendant's motion as he has failed to state a claim upon which relief can be granted. He has not stated a relief that this court is able to provide at this time, nor has he provided a legal basis for the court to provide said relief that he is requesting either in the motion or the request for dismissal in this oral motion being made today. Neither motion has provided any case law that would be dispositive of any issues in regards to dismissal of the matter in its entirety by this court, or provides the court any justification or legal basis for said actions based on that request. But moreover, in regards to the actual issues of any subpoena or any request for documents of that sort, or any request for testimony, some of those requests are at this point untimely, as there is no trial that has been set in this matter. And moreover, this is not the proper methodology for effectuating a subpoena, nor for asking the court in regards to sign or send out any subpoenas. So therefore, because he has failed to state any claims or any grounds upon which this court can grant relief, we're asking that they be summarily denied in this case.
He's relying on sovereign citizen-style arguments, contracts, jurisdiction claims, but none of it fits legal procedure. It feels logical to him because it sounds structured, but legally, it's invisible. And when your argument doesn't exist in the court's framework, the court doesn't debate it, it rejects it entirely.
Can I rebuke that, madam?
Sorry, what'd you just say, Mr. Cunningham?
Can I rebuke that? First of all,
Mr. Cunningham, I'm going to stop you.
Yes, ma'am.
I've read the motion. In fact, I've read it a couple of times and listened to what you have said here today. And I agree with Mr. Danner that there is no support for what you're requesting, and both motions are denied. The oral motion to dismiss that you made today,
How you gonna deny
for a subpoena ducis tecum. They're both denied.
Excuse me. How you gonna deny a fact that basically is not solidified? They don't have the Ryan Kavanaugh on the basically what they sent to me is Ryan Kavanaugh, but now they don't have Ryan Kavanaugh on their witness list. Now, why don't have Ryan Kavanaugh on my witness list is one thing. Now, two, here it is. I'm not supposed to be on U of M property as quote unquote his quote unquote investigator who basically investigate quote unquote, excuse me, shit. Simple fact of the matter is I'm not supposed to be on U of M property. Now, if I'm not supposed to be on U of M property, that means here it is. They have to get some type of subpoena or something to bring me in to solidify that basically I know what's going on at that point in time. Now, here it is. I'm in U of M.
Mr. Cunningham, I'm going to mute you now so that I can speak.
Here it is. They run my territory.
All right. Mr. Cunningham, you have a pretrial scheduled next Tuesday at 1:30, and that's on the same Zoom. We'll see you then, sir. We can call the next case.
Number 4 on the docket, People versus Kevin Bailey, 22-263 FH.
Counsel,
Filber, the ping on behalf of the people, Your Honor. Your Honor, I was actually in a preliminary examination until not long ago.
Number 6 on the docket, People versus Bobby Cunningham, 22-147 FH.
Lieutenant for the people.
Is Mr. Cunningham present?
Cunningham present, visa assumed.
All right, today is a pretrial, Mr. Cunningham. Are you in talks with the prosecutor about a resolution, or would you like a trial date?
Basically, I was asking if I can actually adjourn it. Maybe the prosecutor wants to send some other documents. I have not had any communication with the prosecutor as well, for the record. Excuse me. From my understanding, as me representing myself, from my understanding, under the U.S. Constitution, I have a protected right under the Sixth Amendment of due process, which basically, under due process, I wouldn't be getting due process if I wouldn't question the original witness. In this case, excuse me, ma'am, is it possible that we can both come to the bench?
All right, I'll have a bench conference.
Yes, ma'am.
Back on the record.
All right, go ahead, Mr. Cunningham.
Okay, for the record, my understanding of the U.S. Constitution running concurrent and parallel to the Michigan Constitution, I have a right to due process under the Sixth Amendment law of the Constitution. From there, one, I didn't get to question the original witness. Which basically what they do in this case is stated. Me personally, I'm asking for a mistrial or a dismissal. Under those circulations of the documents that you do have in your hand, and also what was sent to me from the prosecuting office, October before, quote unquote, a backdated amendment, which basically wasn't a motion heard on, which still materials that I asked for, I still didn't have, such as the transcripts and the videos, to better circulate and get other references to for my court case. And it also will be a poison as a fruit of law. Go ahead, Mel. Excuse me. For the record.
Right, Mr. Cunningham, I have a hard time following you and following what you're asking for. And I've had the same problem in the past several hearings as well.
Yes, ma'am.
Today's a pretrial. It's not scheduled as a motion hearing. And what I'm going to do is require that you put your motion in writing and file it with the court so that I can consider it and try to follow the arguments that you're making, and that I can give them the consideration that they deserve. So if there's nothing else, and I'm not hearing anything that I feel that I can handle right now from the bench without having it in writing, I'm going to schedule a jury trial. And that doesn't stop you from filing any motion that you want, but it just puts the case on track to head to trial.
All right. Your Honor, just two things I would like to just place on the record here. Is that one, if the court prior to setting the trial or jury trial in this matter, if we could just, again, because this is the start of another proceeding, just advise Mr. Cunningham of his right to counsel and the cautions for one in representing themselves. And then also just to advise Mr. Cunningham that if you would like to discuss resolving the case, but not the merits thereof, as you have rights, and talking to me about the subject matter of the case may interfere with those rights. But if you would like to discuss resolving the case, please feel free to either call my office or send me an email, whichever one is your pleasure, as far as your method of communication. And I would be happy to discuss an offer in this case and resolving this short of a trial, if that is your desire, sir.
No, that would not be my desire. Once again, on your witness list, since this is a pre-trial, can you tell me on your witness list, you have not kept in communication with me. You have not sent any documents that basically, I only know of your witness list because of certain texts that was sent to me, sir. You have not been keeping in compliance to me to basically update me on your witness list. I've been trying to update you on your witness list. Last motion, I stated that basically it was not on your witness list. You have not even addressed that. I mean, you talking to the courts. Excuse me. You're talking to the court.
Mr. Cunningham,
To still have
this is something you can bring up by way
your
of motion.
witness for what?
Mr. Danner, is September
How long do I
19th
have
an
now?
acceptable trial date to you?
I'm sorry, Your Honor, I didn't catch that date.
September 19 for jury trial?
September 19th, Your Honor. Yes, Your Honor, September 19th would be a, let's see here. Yeah, I believe there's only one other trial scheduled on that date in which I am looking to resolve. So the 19th would work, Your Honor.
All right, and Mr. Cunningham, is September 19 acceptable to you?
That was due, but I have other prior engagements other than, not to be rude, other than staying in Ann Arbor. If you can see some of the documents, state Kentucky. I was never, which the complaints say, homeless, which basically had a whole address
Was that
in
a simple
Kentucky.
no that date is not good for you?
No, ma'am. Somewhere around December
Okay.
would be.
Thank you. October 3. How's that?
Can you put it like around the 19th or the middle of the month?
I can't, I'm out in the middle of the month.
All right,
Is October 3
it is.
acceptable?
Yes, ma'am. It will have to do, ma'am.
Mr. Danner?
Yes, Your Honor, that
anyway,
would work for the people, Your Honor.
Okay, and then final pretrial, September 13.
All right, yes, ma'am. Lou Dane, if possible, could you send your information to my email as well?
Let's see, I can see
He's
if I
given
have
you
it.
his email address previously, Mr. Cunningham.
Well, basically, if possible, that way we can keep communication. He can put a star on it or highlight, so therefore he knows when I send him documents or what type of motion I'm trying to move. I have been compliant and also have every motion gave to the prosecutor, and they have not responded, which basically is leading to quote unquote your time and the taxpayers' time as well. So I just give you my email address out in the public right now. UCC 1-308@writeme.com. You can text me anything you think we can resolve this. You can move it out your day. I can move out my day, sir. Thank you.
Sir, I honestly did not understand that email. I am going to provide you my contact information again, sir, and I would encourage you to please reach out to me in regards to if you have any questions that are not about the merits of the case or to resolve it. I would encourage you, sir, to please reach out to me, and I will provide you my email again. It is my last name, which is on the screen here, DANNER. My first initial L, so it'll be Danner.
Yep.
L.
Was Washington
.org.
.org, exactly.
Yes, sir. And I can give you the number to the main line, and then you can ask for me, and they will direct you right to me. And those calls go right to my cell phone, so I will be able to answer regardless of if I'm in the office or not. Would you like that number, sir?
I can get the number, sir. I've been to the office already several times. I have been compliant. I'm not understanding why the judge, I'm not understanding me being compliant to them, but they're not being
the same respect to me.
Mr. Cunningham, I will address a motion when you file it. I want to warn you yet again, as I'm required to, that representing yourself is not a good idea, that you would do very
So
well
are you my
to
advisor,
allow
attorney
yourself
now?
to be represented by an attorney. And I will appoint an attorney
my
to
attorney?
represent you, or I will appoint an attorney to act as standby counsel to you to help you navigate. But if you have the right to represent yourself, if you do that, you are held to the same standard as an attorney, and you're expected to know and understand the court rules and the statutes, and to not smoke in court.
Oh, excuse me. Can I drink water? There's usually no water right there where I can drink it. Is that all right? Or maybe not.
You may drink water. Are you, would you like an attorney or standby counsel, Mr. Cunningham?
No, I just told you, man. No, not at all.
Okay. All right, thank you. We're all set. We'll call the next case.
Number 34 on the docket, People versus Angela Weems, 22154 FH.
Lou Danner for the people.
Angelo, especially up here.
Sir, would you mind?
Oh, all
I'm
right.
not going to have you eating an ice cream cone.
All right,
in
I'm
court.
sorry.
Your Honor, I had the opportunity to speak with Mr. Weems yesterday as well as today. Our conversation was cut short yesterday due to him suffering a bit of an injury due to a biking accident. But he did in fact reach out to me again before the docket here, and we discussed the matter, Your Honor, and I had informed Mr. Weems of the offer that the people were willing to make in this case, and have also informed him of the charges as they stand as far as all of the 4 counts alleged in the information. I had informed him of the offer and of a sentence agreement, and then informed him that I would need to make sure that I place the entirety of it on the agreement, on the record, before he makes any acceptance, as I wanted, if he was to accept the offer, for that acceptance to be done on the record, Your Honor. So if I may.
Before you get into that, just one second. I know that Mr. Weems is representing himself, but my notes have the public defender as standby counsel.
That is my understanding as well, Your Honor.
All right, Mr. Weems, do you still wish to represent yourself?
Yes, ma'am.
Have you been accepting the help of standby counsel?
Yes, ma'am.
Would you like us to wait until Ms. Noveski can join us in this hearing?
What was Miss Noveski?
She's a public defender?
Oh, well, yeah, please.
Okay, then we'll hold on for just a minute. She's meeting with somebody else in another room. And I'll take this minute to tell you, as I will tell you at every hearing, Mr. Weems, that you're entitled to an attorney. The court will appoint one if you can't afford one, and you would be well served to accept an attorney. You will do better with an attorney, and if you refuse an attorney, you're still held to the same standard as though you were an attorney. That is to know the court rules and the statutes and the case law of the state of Michigan.
Understood.
And we'll just hold on for Ms. Noveski. All right, we're still on the record. Ms. Noveski, we paused for a minute with Mr. Weems because the public defender is standby counsel to Mr. Weems.
Okay. I'm sorry, Your Honor. I
Okay.
didn't remember that.
No, that's all right. That's all right. And Mr. Danner was about to put an offer on the record. That's as far as we got.
Okay.
Thank you, Your Honor. So the offer I had articulated to Mr. Weems, and I believe I also sent an email to the same effect, except for a little difference in the sentencing agreement portion of this to Ms. Noveski as well, is that Mr. Weems would be, the offer would be for Mr. Weems to plead guilty to count 1, the weapons offense, carrying a concealed weapon, and we would dismiss counts 2, 3, and 4 Further, there would be a sentence agreement to no upfront jail, probationary term of 12 months with the possibility of early discharge if all terms are completed within 6 months. And Mr. Williams, would you like to accept that offer?
Yes. Yes. Yes.
I heard you. I'm sorry. I'm just getting ready to take the plea. Mr. Weems, raise your right hand. Do you swear or affirm the testimony you'll give will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Mr. Weems, you heard the agreement that, or the offer that was just put on the record. Is that what you would like to do?
Yes, ma'am. Yes, Your Honor.
Count 3, carrying a concealed weapon has a count 1, carrying a concealed weapon has a maximum penalty of 5 years or $2,500. If you plead guilty, you'll give up your right to a jury trial and your right to be presumed innocent until proven guilty beyond a reasonable doubt. You'll give up your right to have witnesses against you appear and to question those witnesses, and your right to compel the appearance of witnesses on your behalf. You'll give up your right to remain silent and not have your silence used against you, and your right to testify on your own behalf if you should decide to do that. Your guilty plea could be a violation of probation or parole, and there could be immigration consequences if you're not a U.S. citizen. If you plead guilty, you will not be able to claim that your plea is the result of threats or promises not disclosed on the record, and you'll have no automatic right to appeal. So your only appeal would be by permission of the Court of Appeals. You'd also not be able to appeal any issues that might arise during trial, since you won't be going to trial. Do you understand these rights, Mr. Weems?
Yes.
Do you want to waive those rights and plead guilty here today?
Yes, Your Honor.
You've been threatened or coerced to get you to plead guilty.
No, Your Honor.
Have you been offered anything that wasn't disclosed on the record here today?
No, Your Honor.
Is it your choice to plead guilty?
Yes, Your Honor.
You need a sentence agreement sheet. The allegation is that on January 18 of 2022, you were in the city of Ypsilanti in Washtenaw County at East Michigan Avenue on Miles. Is that true?
Yes.
At that time, did you have a handgun concealed with you in a car?
Yes.
And you were driving that car?
I was traveling. Yes.
Are the people satisfied?
Yes, Your Honor.
And the defense?
Yes, Your Honor.
Mr. Weems, are you satisfied?
Yes, Your Honor.
I'll accept the guilty plea, find that it's knowingly and willingly made. And we'll schedule sentencing
July 19th.
July 19. Mr. Weems, do you want Ms. Noveski present for your pre-sentence interview?
Yes.
Okay. You need to call probation to schedule your interview. Can you take down the phone number?
Yep, give me 1 second. I'm ready.
734.
73.
Oh,
go ahead.
sorry.
You
222 3390.
Mr. Weems, please call tomorrow to schedule your pre-sentence interview.
Okay.
And that's it. You're all set, sir.
All right, thank you.
Thank you, Your Honor.
Across these hearings, the pattern isn't emotional, it's structural. Each time the defendant speaks, he's trying to assert control through language. Terms like jurisdiction, contracts, subpoenas, constitutional rights, these are common in sovereign citizen thinking. The belief is that if you say the right combination of words, the system has to respond differently. But the courtroom doesn't operate on belief. It operates on procedure. In the first hearing, the judge gives a clear warning: representing yourself means playing by the same rules as trained attorneys. That's not symbolic, it's literal. And from that moment on, every misfiled motion, every incorrect subpoena, every unclear argument starts building risk. By the second hearing, that risk becomes visible. His filings don't meet legal standards. His requests don't trigger legal authority. And the prosecutor doesn't need to argue facts, they just point out that nothing submitted qualifies as a valid legal claim. That's a critical shift. The case stops being about evidence and becomes about admissibility of arguments. By the third hearing, the court has adjusted its approach. The judge stops engaging with verbal arguments altogether and requires everything in writing. That's not just procedural, it's containment. It limits confusion, forces clarity, and removes room for improvised theories. Meanwhile, another defendant in the same session quietly accepts a plea deal with clear terms, defined consequences, and forward movement. That contrast matters. One path tries to outmaneuver the system using unconventional logic. The other works within it, even if the outcome isn't perfect. And in court, the system only recognizes one of those paths, not because it's fair, but because it's enforceable.